Money laundering. With this presentation, we will be considering the Anti-Money Laundering Act of 2008 and its application to investigations and prosecution, and also the Economic and Organised Crime Act of 2010. Please, if you can turn to your website and you will see the tab for money laundering. If you click on that tab, you will see training material, presentations and guides. If you click on the money laundering law and procedure presentation and also the guide to law and procedure. On the first page, after the title page of the presentation, you will see the heading Types of Money Laundering. If you can also turn to page 6 of the guide, you will see a description of those different types of money laundering. But probably the first step to consider is what exactly is money laundering? Well, it's the disguising or the distancing or the sanitization of proceeds of crime. So it's when acquisitive criminals will try and distance themselves from their profits by trying to find safe havens to hide their criminal proceeds, to avoid investigation, to avoid prosecution, and ultimately to prevent that money being returned through confiscation orders. So in short, it's the cleaning of the profits of crime to try and make it appear legitimate. Now, on page 6 of the guide, you can see that there is a description of the 3 stages for money laundering schemes. Now, of course, money laundering can be very simple, from a handover of cash from one person to another, to highly sophisticated schemes that may require financial investigation and review of accounts. But they all follow 3 basic stages. Firstly, placement. That's the process of getting money into the financial system. So that may be from the very basic level of a criminal banking the proceeds of their drug transaction into theirs or somebody else's account in a bank. Then layering, and that's the more complex system of, through transactions, getting money further away from its source. So that may be moving money from one bank account to another. It may be in terms of placing it into an offshore company so that the individual, the criminal, can hide behind the corporate veil so nobody knows where the money has gone and who then it belongs to when it's invested into an offshore company. The third stage is integration, and that's when ultimately the criminal proceeds have been absorbed into the economy to give the perception that they are legitimate. So that could be, for example, purchasing property. So the house has now been legitimately purchased and the source of the money is no longer known. Now, why prosecute, investigate money laundering? Because it's serious. It incentivizes crime. That's why criminals will do their criminality to render and be able to secure a profit. And also, of course, it enables transnational organised criminals to be able to perpetuate further crimes. They sell their drugs. They are then able to not only purchase more drugs, but then invest in other types of criminality. That may be cyber criminality, human trafficking, to pay corrupt payments to make sure that their companies are legitimised. Many different ways to continue that vicious cycle in relation to criminal proceeds. And then, of course, when the money is integrated into the system, it's not fair on you and me in relation to payment of taxes when we work hard to make sure that we have legitimate money to purchase our food, education, in relation to purchasing property. But if criminal money comes in, then that can undermine the whole financial system. Now, it is always important that you seriously consider money laundering matters. So when you have the public interest element of the Ghana Code for Prosecutors, think about the fact that it's more difficult for criminals to legitimise their ill-gotten gains by money laundering prosecution. It will deter those professional launderers, potentially accountants, lawyers, who may launder the proceeds for criminals. And also, as I said earlier, to ensure the integrity of your financial institutions and also those internationally. Often it's talked about in terms of asset recovery and money laundering. But of course, here we're focusing in relation to money laundering. Later in this presentation, I will talk about asset recovery. But what are the main types of money laundering prosecution? Now, they can be either mixed or it can be in relation to standalone money laundering prosecutions. So mixed, there would be two subsets, and we're now looking at page 7 of the guide. It could be own proceeds or self-laundering, and that could be where I have committed a drug trafficking act, so I've sold some drugs and then I'm seeking to put the proceeds of that drug sale into my own bank account. Or it could be laundering for another person in relation to a predicate offence. So it could be on the basis that a corrupt payment has been made to an individual and that individual has passed the money back to me to be able to pay into a bank account. So consider those two types, own proceeds and laundering for another when it follows the predicate offence. Or it's where the money laundering is the sole charge. So there wouldn't be another charge on the indictment. It would simply be proceeds of crime laundered by myself. So that would either be own proceeds or it would be laundering on behalf of another. So if we turn back to the slideshow, and you could see on the next slide, AMLA 2008. And I just want to go through the ways that AMLA criminalises money laundering. So if you can now go back to the website, look on the legislation, and you'll see the Anti-Money Laundering Act. Click on that link and then go to section 1, subsection 1, and you will see paragraphs A, B and C. So we're not going to look at the first 3 lines in subsection 1, we're going to look at A, B and C. And you can see at A, converts, conceals, disguises or transfers the property. Now, a description has been provided in relation to those specific acts at page 8 of the guide. So it's important to be aware that these must be overt acts. So you're looking at, has the money been converted, so from the money into a property? Has it been concealed in a way? Has it been hidden into an offshore company? And that's very much the same as disguises. Or has the money been transferred between 2 bank accounts? Again, looking back at the Money Laundering Act, paragraph B, conceals or disguises the unlawful origin of the property. So again, that is very similar to paragraph A. But again, it would require an overt act of the accused knowing or ought to have known that the property that has now been concealed or disguised as the proceeds of unlawful activity. And equally to identify that particular act. An example is provided on page 8 to persons in relation to financial credit institutions or accountants who in the course of their work facilitate money laundering. So this could be the classic example of a organised criminal charged with an offence going to see a lawyer lawyer providing a bill, can I have payment please, money brought in, and the lawyer doesn't do any checks in relation to the source of that money, and therefore they're legitimizing that money by then using that to pay their bill, because of course that is money that's from the proceeds of crime and therefore shouldn't be used to pay a bill. Equally, there are professional launderers who will hide the money for organised criminals through complex audit trails, through money exchange bureaus, by purchasing other currency. And this is exactly the type of offence under paragraph B, the actus reus, that would consider. So again, turning to the Money Laundering Act, paragraph 1(c), acquires, uses or takes possession of the property. So this could be for a straightforward handing over of cash. So one party sold some drugs, passes it to another. It could simply be the profits in relation to the selling of the drugs. So again, if I've sold some drugs and then I receive the money, I have possession of that money. Or do I use it then to pay for something, to pay to go on holiday? I've used the money. Or I've acquired the money by somebody else passing it to me, knowing that it's come from, or ought to have known that it's come from, a drug deal. This may have happened straight in front of me. So if we go back to the presentation, we can then see reference to aid and abet in section 2 of the Anti-Money Laundering Act. So if we go back to section 2 and we read that, a person commits an offence if the person knows or ought to have known that another person has obtained proceeds from an unlawful activity and enters into agreement with that other person or engages in transactions where the retention or the control are from the proceeds from unlawful activity, or B, the proceeds from that unlawful activity are used to make funds available to acquire property on behalf of that other person. So again, this offence can be used in relation to those professional launderers. So it could well be a situation, again, where the accountant has said what you want to do is you want to put this money into a financial scheme. It may be in terms of a banking account to save money and then producing a profit from the interest in relation to those proceeds going into the savings account. But the accountant has entered into an arrangement in relation to the proceeds from the unlawful activity. So again, this offence can be used, the aiding and abetting, in relation to those professional launderers. But what is unlawful activity? What do you have to prove as an investigator, as a prosecutor, to confirm that the property has derived from unlawful activity? And this, of course, when we look at section 1, subsection 2, reference is made to unlawful activity is conduct which constitutes a serious offence, financing of a terrorist act, or contravention of a law which occurs after the commencement of this act, whether the conduct occurs in this country or elsewhere. So let's again go back to the guide and on page 9. So what is a serious offence? So a serious offence is defined under the Act as an offence for which the maximum penalty is death or imprisonment for a period of not less than 12 months. So it's a broad definition and will cover virtually every offence in Ghana. Plus, of course, when we read again section 1 subsection 2, when it says constitutes a serious offence, financing of a terrorist act, or contravention of a law which occurs after the commencement of this act. So for any law post 2008, if that has been the unlawful activity that's led to profit being made or benefit being made, then that will be the basis for showing unlawful activity. Very broad definition. So what has to be done to prove money laundering? And this is why it's important to look at other persuasive authorities. In my research, I have not found a precedent or a judgment or a decision in relation to money laundering and the proving of money laundering in Ghana. So therefore we have to look at other jurisdictions. First of all, I want us to consider, is a predicate crime necessary? Is it necessary to show I have this cash and where that derives from? What criminal offence? Or is it simply enough to say, and let's look again at section 1 subsection 2, that it's conduct which comes from a serious offence, financing of a terrorist act, or contravention of a law post 2008. Does that mean I have to say it is a serious offence? Or does that mean I have to say it is the financing of a terrorist act, or it is specifically in contravention of a law post 2008? Or can we say in a broad definition that it is the profits of criminality, and inevitably it's going to be criminality that's for an offence of more than 12 months, because that covers almost every offence in Ghana with a sentence of more than 12 months. Well, let's look at some of the authorities in relation to money laundering from other jurisdictions. So again, going back to the guide, and I'm going to take you to a case of Anwar. Now, on your website, if you click on the menu, and you will see reference to case law. And in that case law, you will see the first reported authority of R against Anwar, the Crown against Anwar. And this is a Court of Appeal decision from 2008 from England and Wales. Now, of course, it's important to note that this judgment is in relation to the law of England and Wales, the Proceeds of Crime Act 2002. But very important to equally look at the facts and what underlines Anwar. So if you click onto Anwar, you will see the background facts from paragraph 2. But in short order, it relates to a drug dealing network, a police undercover operation, and recording of a conversation in relation to the cleansing of money. And then in relation to VAT, or value-added tax fraud, and how to hide the profits in relation to such frauds, who you go to. And then the use of that particular individual in relation to the drug operation. So if I can take you down, please, to paragraph 21. And this is the discussion in relation to what the prosecution have to show for money laundering. And it's a broad approach. So the court decided, if you see on the third line down, we consider that in the present case, the Crown are correct in their submission that there are two ways in which the Crown can prove the property derives from crime. A, by showing that it derives from conduct of a specific kind or kinds, and that conduct of that kind or those kinds is unlawful. Or B, by evidence of the circumstances in which the property is handled, which are such as to give rise, and this is the important part, to the irresistible inference that it can only be derived from crime. Now, the significant difference between the law in England and Wales under the Proceeds of Crime Act 2002 and the Anti-Money Laundering Act of 2008 is that there is an all crimes approach under the Proceeds of Crime Act 2002 in England and Wales. So all crimes can be unlawful activity where property can derive from. But you may consider that in the circumstances the broad definition applies to the Anti-Money Laundering Act because all offences are covered because of the threshold of 12 months and above. So therefore, you don't have to necessarily go down the route of establishing the specific kind of conduct. Of course, if you know it comes from drug trafficking, then you can say that the money comes directly from trafficking. If it comes from a fraud or a theft or from any other dishonest offence, then you can say that the money has come from that particular criminality. But you may consider applying NW, the second limb, that the evidence of the circumstances in which the property is handled are such as to give rise to the irresistible inference that it only can be derived from crime. So consider the following case. So if we again go back on the website, case law, and F. If you click on the link for F, again, this is a case from England and Wales, but could be persuasive. But equally, consider its application on its facts. But this was a situation where there were two individuals going through Heathrow Airport ready to board a flight to Iran. And a sniffer dog detected currency and in all four of the bags that they were carrying. So the two were asked whether they were travelling jointly and whether they owned all the four bags. They presented boarding cards and said they were off to Iran and their passports. And then one of those started talking in a foreign language, whilst the other one said they couldn't understand what was going on, but then said they packed the bags themselves and there was money inside, only £600. It transpired that when the bags were opened using keys relating to one of those who was stopped, that there was only a small amount of clothing, but the vast majority of the bags contained cash of £1.18 million. They were interviewed and they confirmed that they'd been asked to carry the money, and one of those who was carrying said he'd done it 2 or 3 times before, didn't know where the money was coming from, but did it because they needed help with financial problems. And then the other person said she had nothing to do with it. She had never been told what were in the bags and was very shocked to see what was in the bags. And this is exactly the type of case which would fit under that second limb in relation to Anwar, because of course it's considering the irresistible inference. So bags being carried, a lie has been said, knowledge that the bags did contain the money after interview, again changing the account. So this would bring the irresistible inference. Is it the usual set of circumstances that you would be taking £1.18 million out of the country? The irresistible inference is that having lied, the circumstances of the case, that must have been derived from unlawful activity. And the question that I put out to you is, could you use that second limb in Anwar in relation to your legislation? So let's again look at your legislation. So I wanted to go back to the first 3 lines of section 1 in subsection 1. So a person commits an offence of money laundering if the person knows or ought to have known that property is or forms part of the proceeds of unlawful activity. So we can't go as low as suspected, but it's whether a person knows or ought to have known. So would somebody ought to have known, and then looking at the subsection 2 definition of unlawful activity, would somebody carrying that cash, let's take it that it's in an airport in Accra, somebody carrying that money lies to a customs official that it contains only 1,000 CDs, yet when it's opened and the key is on one of the individuals, it actually shows, or actually you find in there, more than 2 million CDs. Is it correct that for money laundering, because clearly under section 1, subsection 1C, that is possession, is it that I have to prove the specific criminality that money is derived from? Or is it sufficient enough to say the circumstances are such that there is an irresistible inference that it could only have come from a serious offence, financing of terrorism, or a law post-2008? Or can you go as far as to say, well, it can only have come from a serious offence, I don't need to specify the serious offence, on the basis that this is a vast amount of money and it's an irresistible inference that it can only have come from a serious offence because it is being sought to be taken out of the country. And again, let's consider the definition of a serious offence. So if you go down to section 51 of the Anti-Money Laundering Act 2008, and you'll see on page 26, serious offence means an offence for which the maximum penalty is death or imprisonment for a period of not less than 12 months. So it doesn't say it is these types of offences. It is a very broad definition of every offence as long as the imprisonment is not of less than 12 months. So in those circumstances, if there isn't a specific definition in relation to serious offence, i.e. it comes from drug trafficking or acquisitive crime, my view is that you can use that broad definition by saying this must come from a serious offence because of the value of the money, because of the actions in relation to those who had possession of the money. They'd lied and they were seeking to take the money out of the jurisdiction, and when they were interviewed they confirmed what they knew or didn't know in relation to that money, but they knew that the bags had money. Change of account. So consider all of these factors together. These cases aren't always easy, but when you have the circumstantial evidence all together, it does paint that irresistible inference. So please consider the authority of Anwar and then the application of Anwar to F. There is another authority on the website of Bowler, and you may want to read Bowler for again consideration of the application of Anwar. It's from Mauritius, but again would be a persuasive authority for you in relation to the application of the irresistible inference. I now want to go to the evidence that you may consider in relation to a money laundering investigation and prosecution. So on page 11, and also you'll see this on the next slide where I had evidence in the PowerPoint presentation. So you'll see that I have listed between pages 11 and 12 different types of evidence that would be applicable. So accomplice evidence. Has somebody actually said where the money derives from? Forensic evidence. Now this can be in relation to contamination of cash with drugs. Be realistic in terms of resources, but if there is cash and there are drug traces on there, then that is a clear inference that it's derived from drug trafficking. Now, there may be evidence of complex audit trials, so you may need expert evidence from an accountant to confirm about the complexity of the transactions, why they are complex, and the derivation of the money in relation to those complex transactions. Then in relation to cash-intensive businesses, where the cash is free-flowing all of the time, that's exactly the area where organised criminals, drug traffickers will want to hide their money. So again, it may well be that you want an accountant to look at the profit margins in relation to businesses to see whether the level of profits is excessive when taken with the amount of property or other items that are available in the shop, and it just simply isn't viable in that cash intensive business that the amount of revenue going through equates to the stock in the shop. Circumstantial evidence. Again, This is the irresistible inference point. On page 12, there's reference to MK and AS. And this was a situation where cash was handed over in the street. Why would two individuals hand over thousands of pounds in the middle of the street if it wasn't in relation to it coming from crime? You could have used bank accounts. Why hand over cash in a bag in the street between two people that didn't know each other? You can use a trusted system in a bank. Why use a system where you don't know who the other individual is? Also consider section 46 of AMLA. Now, important, because in a trial for money laundering, the accused person, AMLA section 46 says, may be presumed to have unlawfully obtained pecuniary resources or property in the absence of evidence to the contrary. So this is if the accused person A is in possession of that property and cannot account for that income, it's disproportionate to their income, or at the time of the alleged offence, obtained access to property for which they cannot provide a satisfactory account. So let's take the example of money being handed over in the middle of the street. Police strike, arrest both individuals, the passer and the recipient of the cash. Both are interviewed and they cannot give an account. They refuse to give an account, or they give an account that this was money from my grand's will and I was passing it over to somebody to buy a car. So if they provide that account, then you can lead on in terms of further investigations, because is it a satisfactory account? Well, what car were they going to purchase? Will there be telephone contact between the two parties arranging for that pickup and then in relation to the purchase of a car? So again, consider section 46. Now, it's also important to review your constitution, because could there be a challenge in relation to innocent until proven guilty? So Article 19 of your constitution at subsection 2, paragraph C says a person charged with a criminal offence shall be presumed to be innocent until he is proved or has pleaded guilty. So is this section 46 of the Anti-Money Laundering Act reversing the burden? Well, then consider section Article 19, subsection 16. So nothing in or done under the authority of any law shall be held to be inconsistent with or in contravention of the following provisions, one of which is paragraph C of clause 2 of this article, to the extent that the law in question imposes upon a person charged with a criminal offence the burden of providing particular facts. So this is where section 46 will be compliant with the Constitution. There is a reverse burden, but it is requiring the accused person to say why they're in possession of that particular property at that time, why they're in possession of the cash, and can they satisfactorily account? So can they provide an account that does justify why the money is in their possession? Now, there could be an argument by the defence that second limb isn't requiring particular fact, but just a satisfactory account. So it's an evidential burden. The satisfactory element, is that a breach of the Constitution? But certainly in relation to providing specific facts for the account of why in possession would be compliant with the Constitution. So remember Article 19, Clause 16. So now we will go back to the slide and we will consider a financial investigation. So if you can now please go to page 20 of the guide. So financial investigations are very important, and you can see the other uses for financial information. So we've considered that financial information is obviously good for a money laundering prosecution, but I also want you to consider what else it can be good for. So it could be very useful in relation to establishing lifestyle and expenditure, but also it could be just for locating a witness or a missing person, or determining somebody's movements. So financial investigations are fundamentally important in relation to other investigations as well. So if you need to locate somebody and they've used an ATM, it may well be that a financial investigator is able to source that information to locate individuals, as well as identifying criminality in relation to acquisitive crime and other offences such as cybercrime. So what tools would the financial investigator use? So again, going back to the guide, and I have a table on page 21 where we go through all of the tools that are available. And here you may want to also open the Economic and Organised Crime Act of 2010. So there are two provisions for searches, which is an essential investigatory power under sections 26 and sections 27 of the Economic and Organised Crime Act. Now, reasonable grounds are required that the tainted property. Now, what is tainted property? So let's look at the Economic and Organised Crime Act, and if you go to section 74, you will have the definitions. So tainted property means property used in or connection with the commission of a serious offence, or B, derived, obtained or realised as a result of the commission of a serious offence. So with that, we need to know what serious offence means under the Economic and Organised Crime Act to use these provisions for search under section 26 and 27. Now, serious offence, that's the definition preceding tainted property, and it includes organised crime, terrorism, money laundering, human trafficking, people smuggling, sexual exploitation, illicit trafficking, drug trafficking, trafficking in stolen other goods, corruption and bribery, serious fraud, counterfeiting, piracy of products, smuggling, extortion, forgery, insider trading. And then look at C, any other similar offence related to that prohibited behaviour. And then B, we have murder, grievous bodily harm, armed robbery or theft, or where there are predicate offences for a serious offence. So again, would cover most offences, especially when we have any other similar behaviour in relation to those offences listed in paragraph A, and it's for a punishment of less than 12 months. So let's go up.
Hello, we are not
to section 26 and 27 of the Economic and Organised Crime Act. So, if during the course of the search the authorised officer finds property that they believe authorised on reasonable grounds to be tainted or not specified in the warrant, then it is possible that that property, and it relates to a serious offence, can be seized. Any article under paragraph B an officer believes will afford evidence as to the commission of the offence, of a serious offence, then again that property can be seized as well. Also consider section 27. So where an authorised officer suspects on reasonable grounds that a particular property is tainted or evidence of a serious offence, then the property can be seized even if a warrant hasn't been obtained. So very important to consider these provisions in relation to money laundering investigations or in relation to those offences that may link to money laundering, that may be predicate if they're known. So again, if you want to search a property, then this is in addition to the Section 88 of the Criminal Procedure Code provisions, but they're very useful in relation to money laundering investigations. And especially Section 27, where an urgent search is required, but always justified. Again, under the Economic and Organised Crime Act, property tracking. So if you need to locate or quantify or locate records in the possession of somebody, then this is a procedural power that does not require a link to tainted property. Only that an officer of EOCO has reasonable grounds to suspect that a document relates to a property transaction or can be used in relation to locating property. So very important in relation to tracing the proceeds of criminality. Section 41 of the Economic and Organised Crime Act, Declaration of Property, said a notice may be served on somebody who's been charged with an offence, but only under this particular act. If you want to disclose the content as provided within 28 days from this notice, then you would have to get a production order. Section 19 of this act also applies to requests for information, and again may be useful because that would be in relation to other individuals who could assist an investigation. And importantly, a failure to comply is a criminal offence with a maximum of 3 months imprisonment. Also to consider that if there is a failure to comply, then a search warrant can be applied for as well. So if evidence is produced as a result of this declaration of property and income that you want to use, then there would have to be an application for a production order, and that's under Section 63 of the Economic and Organised Crime Act. And Section 64, that will go through in terms of the requirements. So whether subject to an investigation, benefited from a serious offence, or suspected of having committed a serious offence, or there is reasonable ground to believe that the person is actually in possession or control of material. The material is likely to be of substantial value and it's in the public interest. So again, consider those matters, but remember that's specific in relation to an authorised officer and their use of the power under the Economic and Organised Crime Act. So you will have to have close relationships with the EOCO in terms of the use of those particular powers, but important that you are aware of them. Now, under the Anti-Money Laundering Act, there is again power for the Financial Intelligence Centre, the FIC, to request information. Now, this would often be used in relation to those who are supervisory bodies, so they relate to those who will have access to information from accounting institutions such as banks. And equally, under Section 29, there is further provision for material to be obtained by the FIC from those supervisory bodies and revenue agencies. Now, it may be that you want to monitor or track what's happening in an account without disclosing the fact that you're monitoring to the subject of the investigation. Section 38 allows the FIC to monitor transactions for 3 months. Now, of course, once you've monitored that, you may want a production order in relation to securing the evidential material. So again, consider the appropriate provision to go and secure the evidence evidentially after the monitoring order is in place. If you go back to the presentation, and now we'll just do a short introduction in relation to asset recovery. So firstly, in relation to cash seizure. So cash seizure is available under Section 33 of the Economic and Organised Crime Act. And it's a very important power in relation to ensuring that you are able to seize cash straight away. Actually under Section 23 of EOCO. So I've put it paragraph 25, page 25, exactly what you need to consider in relation to a seizure of cash. Remember forensics, telephone EOCO. You may want to do a question and answer session with the individual to determine exactly where the cash has come from, and make sure that you do a statement affidavit in relation to continuity of the cash. Now, a freeze order is incredibly important in relation to making sure that the proceeds of crime are not dissipated. So again, consider that under section 33 of EOCA. Very important that you strike a balance. So this is where prosecutors need to speak to investigators, because if there's a covert investigation, the last thing you want to be doing is freezing the money, alerting the subject in relation to the covert matter investigation. But equally, you want to prevent dissipation. So ensure there is that communication between officers before the freeze order is applied for. Confiscation orders. Now, confiscation orders under EOCA can be applied for against tainted property. Remember, the tainted property is the benefit from a serious offence. Or there can be a pecuniary penalty for the benefit derived from the commission of a serious offence. So we're now looking at page 28 of EOCA. Very important in relation to confiscation that there is joint working between the investigators and also in relation to the prosecutors, because it would be fundamental to establish that the property is tainted. So the court will be satisfied that any income of the convicted person did not account for the acquiring of any property in question. So if money has been used from the proceeds of crime to purchase the property without any evidence to the contrary. And that is under section 51(1)(b). Very important to consider that, but you're going to have to adduce the evidence so there is nothing to the contrary. So that's why it must be joint working between the prosecutor and investigator and EOCA at an early stage. Because if you do take the proceeds away, the prison time is an occupational hazard. Taking the proceeds of criminality, remember when we were looking at what money laundering was doing, but equally the proceeds of crime, it is the incentive for organised criminals. It perpetuates further crime. It sustains their lifestyle. So by taking this money away, it ensures, by taking this property away that is tainted and derived from serious offences, that will disincentivise criminals. Now, through pages 28 and 29 and 30, I go through the main elements in relation to confiscation. It can be technical. So it is very important that there is contact with EOCO to discuss the appropriate steps and what should happen, and in advance of any conviction. So you are preserving your position in order to make sure that you can go for confiscation. So very important in relation to reading pages 28 and 29 and 30 in relation to confiscation orders. And remember the pecuniary penalty as well. Pecuniary penalty is very important in relation to whether there is another route rather than going down the confiscation of property. So the executive director of EOCO can apply for a pecuniary penalty, and the court will assess the benefit derived. And that is very important, because you want to make sure that you provide all the relevant evidence so the court can make that assessment about the property that was held by the convicted person on the date of the application and anything as a result of the serious offence. Now, the Act does refer to anything that is acquired before, during, or reasonable time after the serious offence for which the person convicted. No definition of reasonable time. So again, This is where financial investigation, using production orders, monitoring orders, analysis of the evidence, will assist the court in relation to what is a reasonable time to show, to demonstrate, to prove that the property is tainted. Very important, and to show where the property has derived from unlawful activity. Also, it's incredibly important to consider about sham companies getting behind the corporate veil. And it's not uncommon for organised criminals to run a legitimate business. So again, it's important to consider if the court can lift that corporate veil and treat the assets of the company as property of the convicted person, and then they'll be able to satisfy the pecuniary penalty order. And there are authorities, persuasive authorities from England and Wales, that even if some legitimate activity by such firms, then the corporate veil can still be lifted. So again, it's about the lawyers discussing in terms of what is achievable. Now on page 31, I reference what happens in terms of enforcement. Again, important. It's treated as a fine and pecuniary penalty. And in those circumstances, you need to monitor the fact that the pecuniary penalty is paid or otherwise. Something else to also consider will be the interests of third parties. So again, this is looking at section 57 of EIOCA, and that may be another reason why a court may impose a pecuniary penalty if it's transferred the property legitimately to a third party, and it cannot be separated from legitimate property. It may well be that a pecuniary penalty is appropriate. Interestingly, under your legislation, section 55(1) of EIOCA, even if a conviction is overturned, the confiscation order remains extant. Again, that could be subject to a constitutional challenge, but that's what your law says at the present time. Again, interestingly, the pecuniary penalty would not be enforceable after an appeal is successful, and there isn't a substitution for another serious offence. If a person dies who's convicted or absconds, the court can still order confiscation if the property is tainted and proceedings in relation to that serious offence had started. So sections 50 and 56 of EIOCA. So that wouldn't be an investigation, that would be there is a charge and proceedings have started. And if one looks at section 56, it reads very much as if the accused has absconded during the course of a trial. So the proceedings have started in relation to the trial, and then the accused has decided to abscond, or they have died. So there is a procedure under section 50 in relation to notice having to be provided in relation to anybody who has an interest in the property as well. So strict requirements if somebody does abscond, I would say, during the trial, but there is still provision to be able to confiscate the property. That would be different to somebody being charged and the trial hadn't started yet. That wouldn't be, in my opinion, absconding during the proceedings. There would have to be a process by which the property is proven to be tainted, so you would continue an absentia in the trial. Of course, it may well be that there is provision to do a trial in absentia, and in those circumstances you may then proceed to confiscation. But have a careful reading of sections 50 and 56 and the interpretation of the commencement of proceedings and the subsequent absconsion of the accused, or absconding of the accused. Now, turning back to the presentation, I have two slides in relation to arrangements and asset recovery. And I just want to tell you a few short analogies in relation to case examples from the UK in relation to prosecuting money laundering, and then ultimately asset recovery, and the benefits of a joint approach between prosecutors and investigators. So arrangements, they can be quick time. It can be that officers go quickly to a scene where a cash handover has taken place. They seize the cash under cash seizure provisions, but then there is an investigation in relation to the handover of the cash. That is simply it though, handover of cash. And these could be quite frequent money laundering investigations. Irresistible inference on a street, handing cash over between persons who don't know each other. Clear money laundering, possession and also arrangement. Also consider those cases, and quite often drug traffickers or other acquisitive criminals will purchase property in the name of another individual. So it could well be that the wife or the partner of an organised criminal is residing in a property that is in the name of their mother or another family member or their partner. Is that money laundering? Well, in those circumstances, there will have to be a financial investigation. Consider their income. Consider Section 46. Consider when you interview them to say, you reside in this property. Your partner, your mother, doesn't have any income. Is there any evidence in terms of how they have acquired their wealth? Or is it simply a case where you can say the irresistible inference, harder in that particular type of case, because it may well be that the accused comes up with an account and it is a satisfactory account, or it's an account that you can't disprove. Remembering Section 46, the evidential burden remains on the accused, but it is very much in line with your constitution, applying Article 19, Clause 16, that it is an evidential burden, and it would go too far for the burden to be, in my view, as long as that is raised, you will then have to disprove it. So if they say it has come from an inheritance from my father who passed away, well, is there a will? Could you then go under Section 46A saying, well, where is the particular fact? Where is the will? Or is that under Section 46B? You're going to have to work closely between the prosecutor and investigator and following audit trails. So again, please consider the standalone cases, but also those where there is a predicate offence and you add on a money laundering. So quite often I may see, well, there is a drug transaction, money has been secured from that drug transaction, that's part of the drug trafficking. No, separate offence. Money laundering is on the statute book for a reason. It's different criminality. There may be a concurrent sentence because it arises out of the same facts, but it is different offending behaviour. The drug trafficking has taken place, and then the money is the profit from that drug trafficking, and it's in my possession. Obviously, more clear cut if I put it into a bank account because I'm trying to legitimise that money by possessing it in my bank account and I'm concealing it in my bank account. The accused may say, well, I'm not concealing it because you've been able to access my bank account. Not the point. It's in your possession and you've taken the profit from the drug trafficking and sought to legitimise it by putting it into your bank account, which may be garnering interest. So moving on to asset recovery, you've seen that the law can be technical, it is specialised, but asset recovery is fundamental. On the slide you can see a house. This related to a human trafficking investigation and prosecution in the UK. And when children were trafficked into the UK, the profits would be sent back to the country of origin where the organised criminals came from to build these houses. Working through mutual legal assistance to make sure that the property could not be dissipated or destroyed to reduce its wealth, to reduce its value rather, had to work very closely using mutual legal assistance with the other jurisdiction. This will require work between investigators and prosecutors. But as I've said in this presentation, if you don't take away the assets, then that will still allow organised crime to perpetuate. So please consider asset recovery, freezing at an early stage, and then ultimately moving on in terms of the confiscation of those assets. Because prison they can handle. Taking the money away, taking the reason why they commit the criminal offence, no. But this all requires a team effort. I hope the presentation has covered the essential points in relation to your legislation. Overarching theme, work together.